Hello, I'm Christopher Patterson. I am the Chief Judge for the 14th Judicial Circuit here in and for the state of Florida. March 18th marks the annual ceremony and observance that we have of the Supreme Court case Gideon versus Wainwright. It was a seminal case in that it changed the law forever and guaranteed the right to counsel to all persons charged with a crime, whether or not they could afford it. While every law student has studied this landmark case, the case ended in the Supreme Court, but it started here in Bay County, on an ordinary day, on an ordinary docket. Each day, judges in courtrooms just like this, in this circuit, around the state, and around the nation, hear thousands of cases. We take an oath to preside over these cases. And we swear that we will make reasoned and sound judgments based on the law and the facts that are presented before us. But we never know in these courtrooms on any given day when an ordinary docket may make history. Allow me to give you a brief synopsis of how Gideon versus Wainwright started. June 3rd, 1961 was a hot and sticky day. The owner of the Bay Harbor Pool Hall came to work as usual and found that some liquor, some soda, and about $65 in total of money from the cigarette machine was missing. Coincidentally, turns out later that an eyewitness, Henry Cook, had the fortune of walking by the pool hall early that morning and identified the defendant, Clarence Gideon, as the person who had committed the burglary. Clarence Earl Gideon had been a drifter out of Missouri. About 50 years old, he had spent his life committing small-level felonies and some misdemeanors, nothing of violence and nothing of significance. But his life had led him to Panama City, and he had been in the area for a little less than 2 years. The area seemed to suit his gambling habit and his love for playing pool. Clarence Gideon appeared before Circuit Judge Robert L. McCrary Jr. the next day. And Gideon requested that the court provide him with an attorney because he didn't have the money to hire one. The court denied his request. State of Florida versus Clarence Gideon proceeded to trial. And that is where Mr. Gideon had to represent himself. He was shortly thereafter convicted by a jury here in Bay County. Judge McCrary sentenced Gideon to serve 5 years in the Florida Department of Corrections, and he was remanded to the custody of the prison at that time. Featured prominently at that trial was the eyewitness testimony of a 22-year-old Henry Cook, who swore that he saw Clarence Gideon take the liquor and the money. Judge McCrary was a seasoned and knowledgeable trial judge, and in denying the motion for appointment of counsel that was advanced by Clarence Gideon, Judge McCrary relied upon the United States Supreme Court decision in Betts v. Brady, which determined that counsel was not necessary to be appointed and did not violate the Due Process Clause of the 14th Amendment. Judge McCrary may not have been aware that throughout the state of Florida at the time, other jurisdictions were appointing counsel in similar cases on a very limited basis. Notwithstanding, little did Judge McCrary know that his decision, following the law as he understood it, would lead to such a monumental shift in our system of justice. While serving his prison sentence, Clarence Gideon filed handwritten pleadings with the Florida Supreme Court, alleging that his constitutional rights had been violated due to the trial judge's refusal to appoint an attorney for him. The Florida Supreme Court denied his claims, and Clarence Gideon appealed his case to the United States Supreme Court. At the Supreme Court, Chief Justice Earl Warren appointed an attorney, Abe Fortas, to represent Clarence Gideon. And of course, Abe Fortas then became a justice of the United States Supreme Court thereafter. On January 15, 1963, the Supreme Court heard oral arguments in this case, now known as Gideon versus Wainwright. And on March 18, 1963, the highest court of our land, known as the Warren Court, handed down a unanimous decision in favor of Clarence Earl Gideon. Justice Black wrote the opinion of the court, stating in part, quote, "Reason and reflection require us to recognize that in our adversary system of criminal justice, any person hauled into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him." The Supreme Court remanded Gideon's case back to Bay County for a retrial. And before the retrial, the legend here in the courthouse is that Judge McCrary left his bench and walked out in the hallway. And the first attorney he saw was W. Fred Turner. And he asked Fred Turner, "Will you represent Clarence Gideon?" And back then, if a judge asked you to do that, of course you couldn't decline. And so Fred Turner became the attorney of record for Clarence Earl Gideon. Fred Turner would later become a judge here in the 14th Judicial Circuit. At the retrial, attorney Fred Turner zeroed in on the testimony of the 22-year-old, at the time Henry Cook, and how Henry Cook's version of events just could not have happened. It was later determined, after the jury found Clarence Earl Gideon not guilty, that the actual perpetrator of the crime was Henry Cook.
Attorney General Robert F. Kennedy said in a speech before the New England Conference on the Defense of Indigent Persons accused of crime on November 1, 1963, if an obscure Florida convict named Clarence Earl Gideon had not sat down in his prison cell with a pencil and paper to write a letter to the Supreme Court, and if the court had not taken the trouble to look for the merit in that one crude petition, the vast machinery of American law would have gone on functioning undisturbed. But Gideon did write that letter. The court did look into his case, and the whole course of American legal history has been changed. Hello, I'm Mark Sims. I'm the current elected public defender of the 14th Judicial Circuit. You know, it's amazing what has happened since the time of Gideon. Our first public defender in the 14th Circuit was Virgil Mayo. He served for 29 years from 1963 to 1992. Of course, everyone remembers the famous Herman Larimore. He is the second public defender in our circuit. He served for 24 years. Both of them did excellent jobs as public defenders. I had big shoes to fill. This handsome fellow here, of course, is me. And now I'm in my second term as the elected public defender, and I started in 2017. Being a public defender is a great honor. It is a great thing that we are able to represent those who are not able to represent themselves and cannot afford attorneys. All of this was brought about because of one inmate had the courage to file a petition to the Supreme Court and ask for an attorney years ago. And because of that courageous decision, and because the Supreme Court of the United States took time to look into the merits of that case, we do now have a public defender system, not only here in the 14th Circuit and not only here in Florida, but in all of the United States. And we're certainly glad to have this. This is indeed the greatest country in the world.
Thank you for joining us as we make our annual remembrance of the case Gideon versus Wainwright. Who knew that an ordinary case on an ordinary docket in Bay County, Florida, would forever change the legal landscape and change the way that we treat persons accused of crimes here in the United States.